When we seek medical care, we place immense trust in healthcare professionals. We expect them to uphold a certain standard of care. Medical malpractice occurs when this trust is broken. It happens when a healthcare provider's negligence results in injury or harm to a patient. These situations can be, well, confusing and emotionally draining. Understanding your rights is the first step towards seeking justice. Medical malpractice cases are not about pointing fingers, they are about holding healthcare providers accountable. Every patient deserves competent and safe medical care. If you believe you've been a victim of medical negligence, you have options. Knowledge is power, and understanding Florida's laws is crucial. To prove medical malpractice in Florida, 4 key elements must be established. Think of them as the 4 pillars supporting a successful claim. First, the healthcare provider must have had a duty of care to the patient. This duty is established when a doctor-patient relationship exists. Second, there must be a breach of that duty. This means the provider deviated from the accepted standard of care. Third, the breach of duty must have directly caused the patient's injury. This is known as causation. It's not enough for a mistake to have occurred. The mistake must be the direct reason for the harm suffered. Finally, the patient must have suffered damages as a result of the injury. These damages can be physical, emotional, or financial. In Florida, there's a limited time to file a medical malpractice lawsuit. This is known as the statute of limitations. Generally, you have 2 years from the date you knew or should have known about the negligence to file a claim. This is not always the same as the date of the injury. There are exceptions to this rule. For example, if the negligence was fraudulently concealed, the statute of limitations may be extended. It's critical to act quickly if you suspect medical malpractice. Don't let time limit your ability to seek justice. Consulting with an experienced attorney as soon as possible is crucial. In Florida, various individuals can file a medical malpractice claim. Of course, the patient who suffered the injury is eligible. In cases of wrongful death, the deceased patient's spouse, children, parents, or personal representative can file a claim. This allows them to seek compensation for their loss. Parents or guardians can file on behalf of injured minors. The law recognizes that children may not be able to advocate for themselves in these situations. It's important to remember that medical malpractice cases are complex. They require navigating intricate legal procedures and medical terminology. If you or your loved one has been a victim of medical malpractice, reach out to Juan Cordero Lawyers at 3055-258-957 and Lawyers in Pembroke Pines for a free consultation.